Good afternoon. Welcome to the West Virginia University College of Law and the West Virginia University Law Review Symposium, Crime and Punishment, the Legal Ramifications of Prison Overcrowding. I'd like to acknowledge today that the Honorable Judge Gajot is with us, and several other members of our judiciary are watching this program via webinar. I want to welcome them all here today and thank them for participating. I am Joyce McConnell, the William J. Mayer Jr. Dean at West Virginia University College of Law. Today's symposium is made possible through an endowed gift from Mrs. Eleanor T. Donnelly and Mr. Robert T. Donnelly to honor the legacy and memory of their husband and father, Mr. Edward G. Donnelly. He was an 1899 graduate of the College of Law, a long-serving member of the faculty, and a highly regarded leader in the profession. Their endowed gift serves as a model for the rest of us for what an endowed gift can mean many, many years later. Today's symposium grew out of the experience of two of our law review editors who served as research assistants to President and Professor Hardesty, the director of the West Virginia Law Institute, when the Institute was asked by the state legislature to recommend changes that would help implement the former Governor Manchin's and now U.S. Senator's Commission report on West Virginia's prison overcrowding and the resulting burden, financial burden on the state. Our own Professor Bastress agreed to serve as the reporter of the final report. Based on the experience of these students and their roles on law review, they concluded that a symposium on prison overcrowding would both be timely and relevant. They think this because federal and state courts across the country have declared that packed prison facilities reveal a system so flawed that it is tantamount to a violation of the Eighth Amendment to the U.S. Constitution. While Congress and state legislatures continue to increase sentences in the so-called war on crime, they do so knowing the constitutional risks in an economic climate in which the federal and state governments face historic deficits. Thus, prison overcrowding raises constitutional and financial issues that must be addressed together with an understanding that the first is dependent on the second. Many here today would concur that constitutional rights should not and cannot depend on funding, or that spending on prisons should outstrip spending on higher education, which it does now in many states. I congratulate the West Virginia Law Review for its insight into the significance and complexity of this issue, and thank its members, particularly Editor-in-Chief Lee Sparks, Senior Managing Editor Zach Ritchie, and Executive Articles Editors Karina Kendrick and Natalie Korber. I now introduce you to the Editor-in-Chief, Ms. Lee Adair Sparks, who will introduce our stellar panel of scholars and experts on the issue of prison overcrowding.
Good afternoon, students, faculty, staff, and guests. On behalf of the editors of the West Virginia Law Review, it is our joy to welcome you to the 2011 Symposium on Prison Overcrowding. It is our honor to have you all here today. Last night, the Law Review held a dinner for the guests who joined us, and when we were sitting around talking about everything, Dean McCollum and I decided that we needed to keep our remarks as short as possible because what they have to offer us today is so exciting, we don't want to take away from it. However, in the tradition of many editor-in-chiefs who have come before me, I have to thank a long list of people who have helped make this event today possible. First and foremost, we would like to thank Dean Joyce McConnell for her unwavering support of the West Virginia Law Review throughout the year. Today's program would not have been possible without you. We would also like to thank President Hardesty and Professor Bob Bastress for all of their guidance. When we came to them last year and pitched this idea, they sat us down and gave us a little bit more focus and stuck with us through the whole year and really making this a great program. Today's event also would not be possible without Dean Dan Fitzpatrick, Margaret Obush, Brian Caudill, and Louis Mackey, who've done a wonderful job in seaming together all of the logistics. And last, but certainly not least, I'd like to thank executive editors Karina Kendrick and Natalie Kerber, who made today's event possible. At the expense of embarrassing them, I think they should stand up so we can give them a round of applause. Now, without further ado, I think we should get this presentation started. It's my honor to introduce Professor Bob Bastress, the John W. Fisher Professor of Law here at the West Virginia University College of Law. Professor Bastress has been a leading voice in West Virginia's attempts to revise the criminal code. Working in tandem with a special commission appointed by then-Governor Joe Manchin, Professor Bastress drafted the final report written by the West Virginia Law Institute on prison overcrowding in West Virginia. Please join me in welcoming Professor Bob Bastress.
Thank you. And I, too, welcome you, and I, too, will be brief so that we can get on to listening to some people who actually know what they're talking about. As the Dean mentioned, the genesis of this symposium lay in the report and the work that the West Virginia Law Institute did last year under the guidance of Professor Hardesty. And that report was a follow-up to requests made to the Institute by legislators and a follow-up as well to the report of the Governor's Commission on Prison Overcrowding, which preceded our report by a year and a half. There is no doubt of the increase in prison population in West Virginia. We leapt from 1,575 inmates in 1990 to well over 6,000 in 2008, and the number has been steadily climbing ever since. Both the state and county governments have been reeling from the cost of maintaining these institutions and housing the prisoners. The increase followed national trends as the national prison population rose by 700% from 1970 to 2005. These increases were a sort of a coalescence of various forces, which included a change in philosophy about sentencing, emphasizing more deterrence, incapacitation, and retribution over rehabilitation. There was a major crime wave in the 70s as the baby boomers sort of hit the prime criminal age. That produced a get tough on crime political message, which was very popular and led legislators to react by enacting longer and longer prison sentences and elected judges imposing longer and longer prison sentences. The Institute was charged with studying our state criminal sentencing laws and practice to determine if there were improvements that could be made that might lessen the problem of criminal overcrowding, prison overcrowding. We made that study and we provided the legislature with a list of recommendations, almost none of which have been acted upon yet. The consequences of prison overcrowding are dramatic. Professor Dean McConnell mentioned the cost to government. I would add the inability of our corrections department, this is particularly true in West Virginia, to provide the kinds of services to felons that they need to rehabilitate and to return to civil life. And it's had an incredible impact on poor and minority, who are disproportionately serving in our prisons. Another commission about 10 years ago studied the overrepresentation of minorities in the juvenile justice system as well as the adult system, and found that while they are disproportionately high in representation across the country, they were several-fold higher in West Virginia. That commission produced a number of recommendations, most of which have not been acted upon. I might add that one of your panelists today, Norbert Federspiel, was active in all three of those commissions and was critical to what their recommendations that they did make. But there have been some advances in dealing with the problems. This was led by the 2002 legislature, which enacted the Community Corrections Act, and then the state Supreme Court and a number of circuit judges. The Supreme Court led by Justices Benjamin Starcher, the circuit judges led by Marty Gaughan up in the Northern Panhandle and Derek Swope in Mercer County, have pushed a set of programs dealing with community correction alternatives, alternative sentencing, drug courts, day reporting centers, and the like. These are all what are called evidence-based programs. They have been proven to be effective in reducing recidivism and substance abuse, which remains the root cause of most crime. The Law Review then has put together this symposium to, and gathered us here to continue the conversation between the experts and policymakers, and to educate the public and to create the momentum to start working on particular solutions so that we can deal with the problem not only of prison overcrowding, but criminal activities as well. With the panel that the review has assembled here today, I am confident we can meet those goals. And I'm going to introduce now the person who will moderate that panel. He is Professor Henry Weinstein, who has had an illustrious career in both law and journalism. He worked, among other places, for the San Francisco Bay Guardian, the Wall Street Journal, was a longtime contract reporter with the New York Times, and then spent 30 years with the LA Times, working primarily on articles about courts, law, labor, and politics. He has won numerous journalism awards, including the extremely prestigious John Chancellor Award for Excellence presented by the Columbia University School of Journalism, the leading journalism school in the country. He is currently serving as in a joint appointment as a professor of law and journalism at the University of California at Irvine. A highly regarded journalist and lawyer, and I would urge you to welcome Mr. Weinstein.
Thank you for that overly kind introduction, Professor Bastress. I would like to thank you, Dean McConnell, and the members of the Law Review, as well as the Donnelly family, for giving me my second opportunity to come to the beautiful state of West Virginia, and I'm sure it won't be my last. I'd like to just jump right in. As we gather here today, the United States has the highest rate of incarceration in the world. The United States has about 5% of the world's population and about 25% of its inmates. On a per capita basis, for example, we have 8 times as many people in prison as Germany does. More than 1 of every 100 Americans is behind bars. As Dean McConnell alluded to, at the present time, there are at least 5 states, ranging from Connecticut, Delaware, Michigan, Oregon, and Vermont, where expenditures on prisons now exceeds spending on higher education, and there are a number of other states that are about to exceed that. That is a really staggering figure when you think about it. As recently as 2 years ago, the corrections workforce in the United States exceeded the combined workforces of Walmart, General Motors, and Ford. Prisons clearly have been a growth industry in this country. This is a relatively new phenomenon in United States history. As recently as the mid-70s, the prison population of the country was only about 1/7 of what it is now. As Professor Bastress was saying, there have been a number of factors why it has grown so much. The war on drugs has been a major contributing factor, but also changes in sentencing laws, longer sentences, more mandatory sentences, and a growing unwillingness of parole officials in a lot of states to release people who had served sentences, even particularly elderly inmates who are now categorized, in the words of some penal experts, as having reached the age of criminal menopause, meaning that they no longer have a propensity to commit crimes. That is actually an academic term. Since 1991, there has been a significant drop in crime in a lot of parts of the country. There are some people that say this is at least in part attributable to the fact that there are a greater number of people now locked up. It's over 2.2 million, I believe, nationwide. And there may be some truth to that, but the fact also is that there has been, as been suggested earlier, a great human and financial toll as a consequence of, the vast expansion of our prison system. And overcrowding is not just a financial problem. Within the prisons itself, overcrowding tends to create more violence. It causes the spread of infection diseases, and in some places, prisons are so over capacities that it is straining local electrical and wastewater systems, which creates further problems. In addition, when a prison is overcrowded, space that normally or was intended to be used for recreational or rehabilitation activities and is now used to house people in bunks, 2 or 3 layers in gymnasiums, for example, means that you are removing the opportunity to do certain things that would both ease tensions in the prison and to help inmates get prepared to re-enter society. When you leave people less prepared to re-enter society, that, unfortunately, not surprisingly, increases their propensity to re-enter a life of crime, which exacerbates the problem that we're talking about in the first place. My state, California, as some of you probably know, is at the epicenter of this issue. The state has, when I last looked, I think 165,000 inmates. It's far and away more than, California is the most populous state, but we have the most inmates. It's not just that we have the most inmates, but according to official state figures, those inmates are living in housing that was designed for about half that many people. About 1/4 of those people are incarcerated for drug crimes, and also there are a number of people that are in on 3 strikes offenses, including people for whom their 3rd strike was not a violent felony. But whatever you think about the policy question of how all those people got there, the fact is that there are just a lot of them. There have been 2 companion federal court cases running for years in San Francisco and Sacramento, which led to first decisions by federal trial judges and then by a 3-judge panel, special 3-judge panel convened by the Ninth Circuit Court of Appeals, that the statewide prison system was in violation of the 8th Amendment, cruel and unusual punishment part of our Constitution, simply saying that the state was not in a position to provide constitutionally acceptable levels of care. Now, I should tell you that under the United States Supreme Court precedent of Rhodes versus Chapman, a 1981 case coming out of the state of Ohio, a prison is not obliged to provide a great deal of comfort. It is simply required to provide what is known, according to the court, as a minimal civilized measure of life's necessities. And according to the judges in California, that was not met, and they issued an order saying that the state had to reduce its prison population by about 40,000 people over the next 2 years. State officials certainly agree that there is a significant problem. The governor declared a state of emergency more than 4 years ago, but the state says that the proposal that the court made doesn't give the state enough time to fix the problem and that the court went beyond its bounds, so they have appealed that decision to the United States Supreme Court, and a decision is expected by the end of June. As Professor Bastress said, even in a state such as yours, which has one of the nation's lowest incarceration rates, it's becoming a problem. And the report that Mr. Federspiel, among others, was involved in said West Virginia was reaching a tipping point where it could become a very serious problem here. They made a number of detailed recommendations, which were very, very thoughtful. But they also said something, I think, from a philosophical point of view that is very, very important when addressing this issue. And the question was, how can policymakers and the public start thinking about how to get smart on crime, not just tough on crime? A lot of other states right now are trying to come to grips with this, as I said, with early release programs, judicial resentencing, more money for rehabilitation, a variety of other proposals. But it is a very tough issue, particularly coming at a time when a number of the states, in fact every state in the country at one level or another, is facing some kind of a budget crisis that was generated at least in part by the economic meltdown that the country experienced starting in 2008. And I must feel compelled to say that there's not one person in a prison in the United States today that has any responsibility for that, and none of the people that was responsible for those things has yet been sentenced to jail. Pardon the editorial comment. I want to make one other remark just before introducing the other terrific people sitting on the stage. Although it is not the central focus of our discussion today, I would feel remiss that if I did not say briefly but explicitly that in many parts of the country, probably most parts of the country, that this issue has racial ramifications. According to Ohio State University law professor Michelle Alexander, author of a stunning new book called The New Jim Crow, the U.S. currently imprisons a larger percentage of its black population than South Africa did at the start of apartheid. I mean, at the height of apartheid. Just think about that. For at least tens of thousands of these individuals, once they are released, they'll be barred from voting. They'll face significant impediments to obtaining a job or housing. Not surprisingly, that could lead them back to criminal activity. Again, as I say, accentuating the issue that we're here to talk about today. I'd like to briefly introduce the four outstanding lawyers on the stage who will now be talking. Your programs give detailed descriptions of them, so I'm going to be very brief. First, we have sitting next to Professor Bastress, Benjamin Rice, who is currently the General Counsel for the California Department of Corrections and Rehabilitation, an agency which has 60,000 employees. He's been involved in all the major prison litigation in California for nearly a decade. Next down the stage is Norbert Federspiel, who is the Director of the West Virginia Division of Justice and Community Service, who served on the Special Governor's Commission on Prison Overcrowding. He also serves as the staff to the Governor's Committee on Crime, Delinquency, and Corrections. Next to him is Craig Haney, who has not just a law degree, but a PhD in psychology. He teaches at the University of California at Santa Cruz and has been an expert witness in many cases involving prison conditions and the death penalty, including the case that is now pending in the United States Supreme Court. And at the end of the table, last but certainly not least, is Cecelia Klingele, a professor at the University of Wisconsin, who has written a number of scholarly articles on the subject of prison issues. She's the chair of the academic committee of the American Bar Association's Criminal Justice section, and she was a law clerk for Supreme Court Justice John Paul Stevens. Ben, why don't you get us started?
Thank you. It's an honor to be here with such a great panel. I wanted to start and thank everybody from West Virginia, President Hardesty, Dean McConnell, and Lee, and Natalie, and Karina, and Zach have all been gracious hosts, and it's great to be here. The reason I'm here today is to talk a little bit about California and the struggles that we've had, to give an overview of what we've gone through and my personal experiences with it. I worked as a Deputy Attorney General on several of these class actions. I worked as an advisor on these cases to Governor Schwarzenegger, and then I've been the General Counsel the last 2.5 years for the Corrections Agency, dealing with these issues and dealing with the lawsuit that went to the Supreme Court. So I have a presentation. I apologize. The presentation's longer than my allotted time, so you're going to see me click through some of these slides a little faster. So I apologize for that. So here's a map of California. We have basically 33 main institutions. We also have camps associated with that as well. One thing that's unique to California is that we have very large prisons compared to most states. If you look at other bigger states like Texas, who also have a really large prison population, they, for the most part, keep their prisons fairly small, whereas California, the 33 prisons average about 5,000 inmates a prison. Here's some examples. I think this is Pelican Bay State Prison. It doesn't have as many inmates, and the reason for that is it has a very high-level This is where California keeps its separate housing units. Its SHU facility has a lot of gang shot callers. It has 2,380 cells. Currently, it has about 3,200 inmates. This is R.J. Donovan in San Diego. It has 2,200 cells, 4,300 inmates. Right here is Corcoran, CSP Corcoran and SATF. They are two prisons right next to each other. Their respective populations are 3,100 cells, 4,600 inmates, and 3,400 cells and 6,280 inmates. One of the more famous inmates is Charlie Manson, has spent a lot of his time there at Corcoran. This is a CCI Tehachapi. It has basically 4 big pods. It has 2,700 cells and 5,600 inmates. One thing that you'll hear, and Professor Weinstein gave the stat that we have almost double what the capacity is. There's a little bit a point to be made that California, unfortunately, calls every cell that is built as designed only for one person. And the truth is a lot of the cells were built knowing that 2 were going to be there. So when you hear the 190%, or today it's about 173% or 73% double selling, it's a little bit, paints a worse picture than probably it is, and it's certainly not to say that we're not overcrowded, because California is. But the percentages are a little different because some of the cells are appropriate for 2 inmates, while some are not. This goes and shows the population of California. If you'll see back in, just as soon as, I think the year it starts here is 1989. There were roughly 84,000 inmates in California's prisons today. Well, this goes to 2008. There was 171,000 inmates. That number is now down from that. So the other issue I want to talk about, and this goes separate really from the litigation, but what makes it really hard when you're this overcrowded as California is the type of inmates California has. When you get an inmate in who's, let's say, level 4, that's our highest inmate classification, they could have developmental disabilities, they could have mental health needs, they could have gang affiliations. And when you're overcrowded, it makes it a lot more difficult to then figure out where you're going to place that person, because let's say he's a gang, he's Northern Hispanic, you can't put him with the Southern Hispanics. We only have 1 yard where you can have somebody in ADSEG who has mental health problems, and also it has ADA accessibility. Being overcrowded is what makes it really difficult to place these inmates and makes it really hard on the people running the prisons. Here's a picture at one of the dorm facilities when it had 3 inmate high bunks. So this is one of the 2 cases that went to the United States Supreme Court. Coleman, it is a case that was, in September 1995, there was a trial. A special master was appointed that year. Special Master Keating, he has recently been replaced by Special Master Matthew Lopes out of Rhode Island. This case deals with the mental health. Plata is the other case. That's our medical case. It's in front of Judge Thelton Henderson in the Northern District of California. It goes, the complaint was filed in 2001. Other significant events are that a receiver was appointed on February 14th, 2006. A second receiver was replaced in 2008, and the receiver's turnaround plan of action, which included construction, a computerized system, et cetera, that was turned in 2008 and approved later that year. The U.S. Congress passed a bill called the Prison Litigation Reform Act, and as part of that bill, when Bob Dole's comments on when the legislation was passed was saying it gives a lot of authority to one judge to release. It's a really extreme remedy to order a state to release inmates, and you shouldn't give that much power to one judge. And the legislation was passed to have 2 other independent judges sit on a panel with that district judge and say, yes, I agree, the remedy for this should be releasing prisoners. In order to go to a 3-judge court, when the single district judge looks at it, the judge must find that the less intrusive orders have failed to remedy the deprivation of the constitutional rights, and that the defendants have had a reasonable amount of time to comply with those orders. The 3-judge, when it goes to the 3-judge court, what they need to look at is Is the overcrowding the primary cause of the constitutional right, and will no other relief remedy the constitutional violation? Additional parties may intervene, and there's a direct appeal to the U.S. Supreme Court. So in California, normally cases go to the Ninth Circuit before they go to U.S. Supreme Court when you seek cert. This case is a little different. You actually file different pleadings. Instead of filing your cert petition, you file what's called a jurisdictional statement. The motions in 2007 were approved by both Judge Thelton Henderson and Larry Carlton to go to a 3-judge panel. In 2007, the panel was, Judge Reinhart from the Ninth Circuit was added to the panel, and the trial took place starting in February 2009. The reason for the big, couple year and a half in between when it was impaneled and the trial is the judges pushed the parties to settle, and time was taken for that, and then to do discovery for the case and discovery battles that come with that took a little time. On August 4, 2009, the court issued its order finding that overcrowding was the primary cause for the alleged constitutional deficiencies in medical and mental health care. The state appealed. The state's main contentions were really that the district court failed to let the other remedies work. The biggest part of that really was the receiver and the Plata case. As I talked about, the receiver was appointed in 2006. His plan wasn't filed until 2008, and yet the motions in this case were filed early 2007. And so the point from the state was it was too early for the 3-judge panel to be impaneled. The second argument was that it wasn't the primary cause. That was the second argument. And the third, main argument was that the 137.5%, that remedy wasn't based on anything. The court didn't look at overcrowding, and the court didn't allow the state to present current evidence of the current conditions in the facilities. The case went to oral argument this last November, November 30th, 2010. The U.S. Supreme Court heard oral argument. Depends on which observers you ask. I will tell you that I would never want to speculate or guess what the 9 justices will do there. Clearly, there were justices on the left side of the political spectrum who were ready to go ahead and affirm the court's findings. There were judges on the right that were ready to completely overrule it, and everybody was looking to the middle of the court to see what the court would do. I think the court really had a tough time with saying how long should inmates wait. This case is, Coleman's gone on for 20 years. How long do the prisoners have to wait? They were clearly concerned about that and seemed to indicate they agreed with plaintiffs on the primary cause arguments. The one they really struggled with, I think, and where if you see any type of remand, which is certainly a possibility that they'll send it back and not that nobody will have the quote-unquote clean win in the court, is that they'll send it back and look and say, you didn't really look at, what the current conditions are, the 137.5%. What was that based on? You heard testimony, it should be 145 or 130. What's 137.5? The states had submitted a plan in 2009 that said that we'd get down to 137.5 in 5 years. Why didn't you accept that plan? So those type of issues I think the court was struggling with. I wouldn't be surprised to see and I'm not going to guess what they're going to do, but certainly is one thing they might do is remand it to look at those issues. One thing, looking at California, as it was talked about earlier about how from the 70s to now, how much prison population has gone up. California's, for example, has gone up 750%, rising from 20,000 inmates to 170,000 inmates. One of the things that was already discussed is Governor Schwarzenegger in 2006 issued an emergency proclamation regarding the state of emergency, the conditions in prisons that were leading to more violence, and the conditions that were tough to work in, and the conditions were bad for inmates. What has happened since then is you've actually seen you had an steady increase in California's prisons for years up through about 2006, 2007. Since that time, the prison population in California has actually gone down quite dramatically. The number of inmates that are under our jurisdiction hasn't quite decreased. It stayed about actually even, which is something to say in of itself when the population goes up 1% or 2% a year, but the prison population stays the same. In addition, the prison population in California's 33 prisons have gone down 20,000 inmates, which is pretty significant. The reasons for that are 10,000 inmates were sent out of state, so there's about half of the solving the problem was sending them somewhere else. The other 10,000, there were reforms that were passed. It was called SB, it was Senate Bill 18XXX in California, and what it did was it started using reentry courts, and I think it was mentioned in West Virginia's report about how these inmates are coming back, and that was one of the parts of the bill of California, is the recognition that save a small percentage who are serving true life without parole. Everybody else is coming back in California and in West Virginia as well, and that you should look at using these reentry courts. The other part of it was a parole reform, was to look at non-serious, non-violent, non-sex offenders and have them only come back on parole only if they committed a crime and not if they only committed a parole violation. More recently, the new governor, Governor Jerry Brown of California, submitted on January 10th a new budget proposal, which was recently amended last Friday, which will significantly have a dramatic effect really on California's prison population, because a lot of non-serious, non-violent will just be held in county jails. And probably the biggest piece is that the proposal is that no parole violators would come back to California's prisons, which is really significant. It's about 14,000. If you looked at an average daily population, if you looked at one day, you just looked at our prisons, you would look and see there's 14,000 people that are there in California on a parole violation. What's more significant about that is they only serve 4 months, so you really have about 42,000 inmates coming in each year into our reception centers, which is takes a lot of toll on people that are providing them mental health and screening them, et cetera. It'll have a significant role on reducing the population in our reception centers. So I know I'm past my time, so thank you.
Dean McConnell, President Hardesty, members of the audience, it's a pleasure and a privilege to be part of this wonderful panel. I feel a bit overwhelmed since I'm a mere state bureaucrat instead of a longtime scholar who publishes many articles. I've got about 10 minutes to go over about 30 years of history, hit a couple of court cases, and talk a little bit about prison reform activities. Wrong direction. Here we go. I don't know how many of you have had the opportunity to visit the old penitentiary in Moundsville. For those who have not, I suggest you do. This, I think, is an important piece of history. The case that came out of it, Crane versus Bordenkircher, started in 1981 as a habeas corpus petition by Mr. Robert Crane and others against the prisons at the time. We had just over 1,000 inmates in the state at that time, and Moundsville, together with Huttonsville, were basically the men's prisons, and I think the women were in Penn Springs. But we had very small, relatively speaking, compared to Ben, prison population, but it was a horrendous prison. The Supreme Court remanded the case to the Circuit Court in Marshall County, Moundsville area. They had trial there. The judge took a tour of the facility, 3.5 hours. They appointed a special master. They looked in every nook and cranny. They found out a truly deficient facility, terrible plumbing, dangerous electrical wiring, dangerous humidity situation, dangerous overcrowding, and especially when you get to the North Hall, dangerous cages were 35 square feet where they'd put 2 people. We're talking cages. We're talking third world. I've been in a lot of prisons over the course of my career, visiting and counseling and so forth. This is absolutely the worst one I've ever seen. Now, fortunately, I didn't see any inmates in it. It was after closure, but it is quite a place. Anyhow, the court determined that, the lower court determined that it was cruel and unusual punishment on the totality of circumstances. That was not appealed by the state, and so that is the finding that, in fact, Moundsville was cruel and unusual punishment. And the court ordered the state to build a new prison, and one was ordered and scheduled to be built up at Mount Olive, and the opening date was supposed to be July of July of 1992. Guess what? They didn't make it. They didn't make it because it takes time to get the cooperation of all three branches of government to solve the issue. When you talk about prison overcrowding, please get off the case of the criminal justice system. It includes the criminal justice system, yes, but it includes the legislature, it includes the judiciary, and ultimately includes the citizens who, unfortunately, we've not educated enough to let them know that punishment can be done in many ways more effectively and reduce recidivism and produce public safety in better ways than putting all people in prison. The creative solution to that was West Virginia created the West Virginia Regional Jail and Correctional Facility Authority, and that authority was able to bond and to build prisons. And it also, and very creatively, built a system of regional jails. This is a very unique system in the nation. We have 10 regional jails. They have replaced all the county jails. As a result, within the past 25 years, we have no jail that is older than 25 years old. All of them have been built within the past 25 years. They've been built in part with bonding money, and that bonding money has also enabled the Division of Corrections to build Mount Olive, and they've also built several juvenile facilities with it. Currently in West Virginia, the West Virginia Division of Corrections includes 13 facilities, one for women and the rest are for men, 5,100 beds. I say beds, not cells. Cells, I believe the count is 1,180, 1180. We have some bad people that are being held in dormitories. Doesn't make sense, dangerous, hard to handle. The regional jails built 10 facilities around the state, and with original design, they put in 2,784 beds. Just a picture of where we're at. As of December 31st of this year, with 6,681 offenders sentenced to the Division of Corrections. The latest projection is that by December 31st, 2015, we'll have 8,251 unless we change our ways. You'll notice that 6,681 is slightly more than 5,100. What do we do with the excess? Well, this is where I say, for the sake of argument and just to be incendiary, we don't have a prison overcrowding problem, we have a jail overcrowding problem. If you take a look at this, I asked the population count for Valentine's Day. I thought that was a wonderful day for it. The current count on Valentine's Day for the state regional jail authority was 4,310. You'll notice that the original design was 2,784. They added bunks, 209 prior to 2009, and in 2009 they added 970 bunks. And you'll notice the excess on that day, there were 347 people sleeping on the floor, folks. And why is that? In large part, it's because 1,677 people who have been convicted and sentenced to the Division of Corrections are sitting in a regional jail. Now, granted, they do pay, the Division of Corrections does pay the regional jails the daily per diem, and that does help keep the jails running and helps to keep the county per diems down. But the thing about a jail, and maybe I should explain this, a jail is meant for short term. It holds you. There aren't many fancy facilities there. There aren't places to get trained or treated. A prison, you have much more freedom to move around. You have many more opportunities to get the treatment that you may need. It's an important distinction. In fact, it's such an important distinction that another case arose in the year 2000 that we called Sams v. Kirby, Sams versus Commissioner. And this was an act in mandamus, special plea. And this one is so unique in that it is different from the Bordenkircher case. That one was, get me out of this place, please. This is terrible. This one is, get me into that prison system, please, because jail is not where I want to be. I don't have the opportunities for rehabilitation. West Virginia created a statutory right to rehabilitation, is what the court found statutorily, and it's enforceable under Article 3, Section 10 of the West Virginia Constitution, due process, substantive due process, and equal due process. We have looked, as Professor Bastress indicated, at alternative sanctions. In 2001, the legislature passed the Community Corrections Act. Currently, there are 17 community correction programs covering 44 counties. As of Valentine's Day, there were 2,478 people sentenced to the Community Corrections Program. Now, in order to be sentenced to the Community Corrections Program, you have to have committed an offense for which you could serve jail or prison time. The Supreme Court has also worked with several courts to set up drug courts, and there are 267 current drug court participants. Some of those drug court participants may also be in the community corrections program of their locality, the Day Report Center. So there might be some overcounting, but we have taken a step since 2001, and actually this is 1,000 people more for the daily count than were in the system at the time that the Governor's Prison Overcrowding Commission was formed. Let me talk about the Governor's Prison Overcrowding Commission. In late 2008, there was discussion by the Governor and the Secretary of Public Safety, what can we do about prison overcrowding? And one of my proudest accomplishments, and I say this with only a slight sense of irony, is we managed to get the signature of the Governor, the Chief Justice, the President of the Senate, and the Speaker of the House on one piece of paper inviting people to a symposium on prison overcrowding. That was held in November of 2008 with assistance from the National Governors Association and the Pew Charitable Trusts helping pay for the costs of the experts we brought in. And the result of that wide-ranging group, a cross-section of the state, and meant to get buy-in from everyone, was the recommendation that we go further. And so the Governor, in early 2009, appointed his members to the Governor's Prison Overcrowding Commission and invited the Chief Justice to nominate members to sit with the group, and invited the legislature to have participants in the group, recognizing separation of powers. The piece came up with 14 recommendations. I'm not going to go all of them. The number one recommendation, and I think this, to me, this is the important one, is the use of a recommending the use of a standardized risk and needs assessment tool. All the way from the initial intake of an offender into the system, through sentencing, through participation in the institution or in community corrections, until he is released through parole or released at the end of his sentence. Risk and needs, and then using that tool for classification purposes, but also to determine what treatment needs the offender has. One of the things that offenders are smart. Some of them are smart. They know that if they go through the process and get some treatment, that they'll get out sooner. Well, if the only treatment that you have, and there is good substance abuse treatment in the West Virginia prison system, if the only treatment you have is substance abuse, and you don't have a substance abuse problem, but you know that you want to game the system, you get substance abuse treatment, which teaches you how to abuse substances. It's not a good setup. But among the other recommendations we made, though, is to increase the capacity to treat substance abuse and mental health services in the community. Folks, our criminal justice system, our jails and our prisons, are the mental health system of last resort. And it's a shame that those who have behavioral health problems, who may not want to take their medication, have to spend time in prison because they have disassociated, they have not followed through on taking their meds. they're not necessarily bad people. They just have behavior control issues. And I think that needs to be recognized, and I strongly urge people to consider an increase in the number of service availability for behavioral health purposes. We also recommended transitional housing. It's one thing to get treatment in the institution. Besides, you have 3 square meals a day, you are very regimented, and then you are sent back to the community where you have little support and little opportunity to take care of yourself, and you end up back with the same people that you started with. Transitional housing is important as a means of continuing your treatment and rehabilitation. We recommended the review of the criminal code. Professor Bastress has noted that that has been largely ignored by the legislature. And we talked about increased data sharing. You know, if we can share data between systems, not just the criminal justice system, but I'm talking about treatment purposes with the behavioral health system, we can do a lot to, again, reduce the opportunities for recidivism, reduce the rate of recidivism, simply by making sure that people get the treatments that deal with their specific needs, be they educational, be they emotional, be they haven't learned how to play in the sandbox with one another. If we can address those, then we can reduce recidivism and the rate of incarceration. That's my name. Be willing to answer any questions in the future, and it's been an honor. And please consider looking into this issue of prison overcrowding, because it is crucial that we somehow face it and protect the quality of life for our citizens.
Thanks to President Hardesty, Dean McConnell, the Law Review. I do a lot of these symposiums on different academic topics, and I don't think I've been to one. I can't remember having been to one that was as flawlessly organized and as warmly and wonderfully put together as you folks have done it. So thank you for the invitation, and thank you for the hospitality. I'm going to speak as a psychologist and not as a lawyer. You've heard from, and you will hear from another brilliant lawyer. I want to give you a different perspective on some of these issues. And I want to step back from some of the things we've been talking about and then drill down as deeply as I can in the 10 or so minutes available to me. I want to talk about this crisis by the numbers first, and let you know, let you see visually some of what you have been hearing about in the form at least of graphs and charts and things. The United States, for as long or since these statistics began to be reliably collected in the mid-1920s, incarcerated about the same number of people for almost a 50-year period of time, and the graph doesn't look much different if you graph the rate as opposed to the actual overall numbers. So from mid-1920s to the mid-1970s, we incarcerated in the United States about 100,000 people per, about 100 people per 100,000 in the population. And it's an extraordinary statement because realize that there were extraordinary things happening in the United States over that period of time. There was the Roaring '20s, there was the Great Depression, there was a run-up to World War II, there was World War II itself, the aftermath, the Korean War, the Civil Rights Movement, the wild and crazy '60s, and the rate of incarceration remained roughly the same, approximately the same as in Western European nations. In the mid-1970s, something very dramatic began to happen in the United States. The rate of incarceration began to increase rapidly. It doubled again, it almost doubled one more time. We very quickly went to being the nation that led all others in the rate at which we incarcerate our citizens. We had some nominal competition in the 1990s from two nations that underwent wrenching political and economic change, South Africa and the former Soviet Union. But we now are far and away the world's leader. These are 2005, 2006 statistics. We are now even farther ahead of our nearest competition. Not only did lots and lots of people come into prison, but lots and lots of people came into prison suffering from mental illness. And this was a change in the composition of the population of people in prison. We began in the United States in the late 1960s and then throughout the 1970s to depopulate our mental institutions. And people who were formerly housed inside mental institutions, many of them ended up in the state's correctional systems around the country. If you put those two graphs that I just showed you side by side, you can see that at around the time that our incarceration rate began to dramatically increase, the mental health hospitalization population began to decrease. There were many, many more people who went into prison than can be accounted for simply by the mentally ill, but you can see obviously many of the people who had been formerly hospitalized mental patients were absorbed into the prison system. You've heard allusions already to the fact that the pains of imprisonment fall disproportionately on some groups in this society more than others. Clearly, prisons are for the poor, but prisons also are for people of color. So when we talk about the crisis of overcrowding, when we talk about the dramatic increase in rates of incarceration in the United States, we're talking about a phenomenon that impacts people of color in this country in the way that it does not impact people who are not from minority communities. These are statistics based on rates of incarceration in 2001. They haven't changed much. The only thing that's changed in the United States is that the probability of a Hispanic male going to prison has increased some in the United States. But it is still the case in 2011 that African American men have a 1 in 3 chance of being imprisoned at some time in their life. Prisons are full around the country. Some prisons are in absolute crisis state, so those prisons on the map that are in black, including my state, California, are in a crisis. They have over 140% of the capacity that the system was built to hold. You can see that your state, West Virginia, is in the bordering on a crisis state. So these are the dark green states that have something above 100 and 110% of capacity, but not quite up to that crisis 140% capacity. You've already seen some of these statistics from my colleague from California. The fainter column on this graph is the capacity of the California Department of Corrections, and the unfortunately much taller red column is the actual population of the California Department of Corrections. We began to become overcrowded a little later than some other places in the United States, and in West Virginia you've come to it much later in the process. We began to be overcrowded in the early 1980s, but this graph it actually provides a kind of a cautionary tale, because I would suggest to you that in the early 1980s, mid-1980s, even as late as the late 1980s, we were in a position in California to do something about this problem, and we did nothing. We built some prisons, but we did not implement any of the kinds of things that many people, myself included, were urging state government to do to get a handle on what was rapidly becoming an uncontrollable prison overpopulation crisis. We now find ourselves in a position where we are operating at nearly 200% of capacity. There are prisons in California that are operating at less than that, but some that are also operating over that. And we really are faced with a daunting problem that we are hard-pressed to figure our way out of. The state of West Virginia, interestingly enough, is at around that point that we were in the early 1980s in California, where we understood we had a problem. The problem was getting worse, and we didn't, and I hope you will, begin to do something very serious about it, because there is a kind of inevitability to this graph, I would suggest to you. If you don't do something proactive to begin to deal with these problems at the time when you can manage them, then you end up where we ended up in California. You end up with a system that is operating unconstitutionally and dysfunctionally and operating in ways that, in my opinion, harm tens of thousands of inmates on a daily basis. Let's look at what these numbers translate into in terms of day-to-day realities. In the mid-1970s, the average prisoner in the United States was housed in a 60-square-foot cell, and he was housed alone. Double celling was not the norm. It was understood in those days that single celling was the appropriate correctional response to incarcerating somebody, and that double celling was a danger. 60 square feet, if you have a king-size bed at home, that's roughly the size of your bed at home. In that environment, you have a bunk, you have a toilet, a sink, If you have access to a television, you'll have that there. You have all of your property stored in your 60-square-foot cell. Beginning in 1975, however, many inmates, and eventually all inmates in the United States, had one more thing in their cell: a friend. A friend if they were lucky, an enemy if they weren't, because as the overcrowding increased, prisoners then began to be regularly double-celled. So you had in that 60-square-foot space another person who also had to live there, have their property, and so on and so forth. And that was, of course, if you were lucky enough to have only one other person in your cell. A number of prison systems went to triple and quadruple celling, and that assumed, of course, that you had a cell at all. Many prison systems dealt with overcrowding by putting people in dormitories, unsafe, unhealthy environments, but prison systems did it that way nonetheless because they were overwhelmed by numbers. And that assumed that you had a dormitory at all, because what a number of systems began to do, and this is a picture from my state, California, was convert gymnasiums into dormitories and house prisoners inside areas of the prison that were originally designed for something else. All of this adds up to, from a psychological perspective, very, very serious kinds of problems. The first thing that this kind of overcrowding does is it dramatically escalates the pains of imprisonment. The awful, anguishing experience that prisoners go through on a day-to-day basis by the sheer fact of their confinement is amplified by conditions like those that I've showed you. It increases the stress and frustration and dehumanization and degradation and humiliation that prisoners suffer on a day-to-day basis. Imagine yourself the inmate on the middle bunk in this converted dormitory, and that is your life. That is your space. That is where you hold all of your property. That is where you wake up in the morning, and that is where you go to bed at night, and oftentimes that is where you spend significant portions of your day inside a unit that looks like that. Or imagine you are one of the prisoners who is living in the inside of a day room in a cell block. And so you live your life, you go to sleep, you wake up in the morning in the plain view of the other prisoners who are housed in this cell block. Or imagine you're one of the prisoners in the cell who used to have a day room inside their cell block, but now it's filled with 140 prisoners who are on triple bunks in front of you. Prisons that are overcrowded break down quickly. They get dirty and are difficult to keep clean. Plumbing, heating, all of these things break at twice the rate if you have twice the number of people who are using them. It multiplies the opportunities for conflict. Cramming lots and lots of people together when they have very little to do, when they are under this kind of stress, when they are feeling this kind of degradation and humiliation, increases the sheer number of times trouble can arise. And it subjects prisoners to more forceful and degrading forms of control. Prisons that are faced with these kinds of conditions have to figure out how to control those prisoners. And so they resort to all sorts of things that they would not otherwise do, but have to do because there are simply too many people for them to control any other way. So they put weapons inside housing units. They put prisoners in cages. Or they put them in violent prisoner restraint chairs in order to deal with the consequences of overcrowding. The second thing that happens, so the first thing is there's a level of prisoner effects. Things happen directly to prisoners. Then there are things that happen to the prison. The prison can't function properly when it is overcrowded in the ways that many of our facilities are overcrowded. Creates widespread and chronic idleness. There's simply not enough for people to do. We can barely find places for people to sleep in a prison that's 130 or 140 or 180% overcrowded. If you can't find places for them to sleep, you can't find, of course, anything for them to do. In 2006, literally half of the prisoners who were released from the California Department of Corrections, that's that first cell at the top, literally half of them did nothing for their entire period of incarceration. Now, some of them were only there on parole violations, and they were there for a period of 4 to 6 months. They did nothing during that period, but others of them were there for years. They were not involved in a program. They had no work assignment. They were literally idle for the entire period that they were incarcerated. And prisoners who were lucky enough to get into a program, an educational program or a vocational training program, these are the circumstances under which those programs were implemented. So imagine you're this guy and you're studying for your GED under those circumstances. The other thing that happens when the system begins to break down is the prisoners' needs, including their criminogenic needs. The things they went to prison because of that needed to be addressed while they were in prison can't be addressed. They're increasingly ignored, not because the prison doesn't want to deal with them, but because it simply can't. Again, imagine you are in this environment and you've gone there with a mental health problem or a drug addiction, or you've gone there with poor education or no work or job skills. And how, ask yourself, will you obtain them living in an environment like that, in a prison that is run under those kinds of conditions? Prisons, of course, when they look like that and they're run like that and there's that many people and they're that idle, they begin to feel increasingly unsafe, and they are. So imagine you are a prisoner in this unit, and this is your day-to-day environment. Or imagine even that you're this correctional officer. I interviewed this correctional officer from a stand, a platform in this housing unit. When she stood out over it, and we looked out over the unit that she was in, and I said to her, "Officer," and I pointed all the way to the back, where you could barely see at the back of this gymnasium, and I said, "What happens when you go back there? What happens to you when you go back there?" And she looked at me and laughed and said, "I never go back there. I wouldn't go back there." So you create environments that are unsafe for the people who live there and that are unsafe for the people who work there. Then the other thing, at the very extremes, the kind of extremes we've been dealing with in California, is there is systemic dysfunction. The system can't function. Diseconomies of scale. At a certain level, so many people mean that the prison simply cannot be run in a constitutional manner. It doesn't matter how much money you infuse into it. It doesn't matter how many court orders a federal court directs to the prison system to fix this and fix that. It simply can't do it because it is overwhelmed by the sheer numbers of people who are there. The minimal civilized measure of life's necessities, however minimally you define that, cannot be delivered in an environment that looks and feels like that. Medical and mental health care cannot be properly provided, notwithstanding the billions of dollars we have spent in California. I started working on the Coleman case in 1991. The trial was won in 1995. It's 2011, and the California Department of Corrections is still telling us to wait and give us a few more years. We'll fix this. It's not because they're callous. It's not because they don't care. It's because the sheer press of numbers makes it impossible. An environment like this cannot be healthy in a medical or mental health sense for the people who are confined there. Despite all the billions of dollars and all of the court orders, this is our suicide prevention program in the administrative segregation units. This is how desperate the situation gets when a system gets near 200% of its capacity. And then what happens is the unconstitutional conditions and the neglect of prisoners' needs, including their criminogenic needs, combine to make prison overcrowding self-aggrandizing. And what I mean by that is it begins to compound upon itself because, as you've heard and as you know, people get out. But they get out having been damaged by the experiences which occurred while they were in. Not only does the prison not accomplish something positive by helping them with the problems that they had when they entered, but it worsens their mental state, it worsens their capacity to stay crime-free when they're released, and they begin to recidivate at higher and higher levels, which compounds then the amount of overcrowding in the system itself. And it compounds all sorts of other problems as well. So this is the increasing number of mentally ill prisoners in the California system, starting 10 years after the Coleman court order insisted that California begin to operate a constitutional system of mental health. Billions of dollars began to pour into this system. The Department of Corrections, as creatively as it could, tried to revise and deliver mental health care as effectively as it could throughout the system, and still the number rises. The percentage of people incarcerated in the system with mental health problems continues to go up because of the conditions under which they are living. Conditions like this. You are on the verge of this in West Virginia. Do something now. If you don't intervene in this process, if you don't get a handle on this problem at the point in time at which it is still potentially manageable, you end up in a position like the one we're in California, where we are all hard-pressed to figure out how to think our way out of this crisis and this tragedy. Thank you.
Hello, I want to echo earlier panelists' gratitude to the Law Review and the administration and all of you here at West Virginia College of Law for inviting me today. I'm learning a lot from my co-panelists and hope that you are enjoying engaging actively in this very important issue as well. You've heard a lot today about the scale of the problem that we're facing in corrections throughout the country and that your state is facing as well. What I want to do is talk a little bit about what the answers might be. Now, constitutional litigation is one way to challenge prison overcrowding and prison conditions, but as many of you who are law students know, there are limits to what the court system can do to fix broken systems, especially when those systems are largely administered by the states and not the federal government. As a result, it really takes legislative changes by people on the ground in the states, supported by the citizens of the state, to make substantial and lasting changes. Now, again, I'm going to ask you to bear with me for just a second as we revisit a little bit of history that you've already heard. You know that throughout the period beginning in the late 70s and continuing really until last year when we saw our first stabilization of the custodial population in many decades, prison populations around the country have risen and risen dramatically. And the reasons for that are many. I want to focus on one little piece of history, though, that I think is particularly relevant to the conversation that needs to happen around legislative changes that are taking place now. From the 1970s, or I'm sorry, from 1900 through the 1970s, the chief way in which people were sentenced was through what was called indeterminate sentencing. So a judge would impose a sentence, usually of a range of years, specifying a maximum term for a sentence. The actual moment of release was not determined by the judge, however. It was ordinarily determined by release through discretionary decisions by parole boards, paroling authorities. The idea was that while in prison, people would seek necessary treatment, and then when they had secured that treatment and no longer posed a threat to the community, then they would be released by the parole board and returned to their communities for reintegration. The rehabilitative ideal and the indeterminate sentence that executed that ideal came under fire in the 1970s. And the reasons for that were many. Some of them centered on the lack of effective rehabilitative programs that were available at the time, some disillusionment about the ability of parole boards to actually gauge the safety of inmates, and a lot of it centered around the lack of accountability of executive branch officials who were making release decisions. There were concerns that these decisions were unaccountable, they were invisible, and they lacked some of the transparency and legitimacy that surrounded the original sentencing decision in particular. As a result of that and increases in general punitive sentiment among the population, we saw a move away from the indeterminate sentence beginning in the 70s and continuing through the turn of this century, and a move toward what has been called determinate sentencing. Truth in sentencing is probably the phrase with which you are most familiar. In a determinate sentence, the judge sets the sentence, and it is, with very small exception, not negotiable. Although a sentence may be subject to a short reduction for good behavior in prison, ordinarily the prisoner will serve the full term of the imposed sentence. Now, that's important because as releases decreased through discretionary parole, sentence lengths were increasing, and that drove much of the increase that you see in the population here. So, why is that important? Well, as legislatures begin to try to wrestle with the options available to them now to reduce custodial populations, I think that there are some historical lessons they need to keep in mind. First, though, I want to talk really briefly about the options that are on the table and the ways in which states have considered reducing correctional populations. The first of these is through front-end reforms, I'm going to call them, efforts to keep people from coming into prisons at all in the first place. The broadest and probably most effective way of doing this, though also the least popular, is through decriminalization. If you take charges off the table, then people cannot be convicted of them and they will not go to prison. Now, it's very difficult, of course, once we have sanctioned behavior as subject to official state punishment, to then say, well, we don't like it, but it's not that bad. And as a result, although decriminalization is a way to very effectively reduce the options available to prosecutors when it comes to actual charging and conviction, we haven't seen large-scale efforts across the country to decriminalize. The next way is through penalty reductions. What we saw during the tough-on-crime period of the 80s and 90s was an increase in penalties, mandatory minimum sentences, 3 strikes provisions, and other measures that increase the maximum penalty for most crimes, including low-level felonies. So an effort to scale back the period during which people can go to prison, if they can go at all, could involve penalty reductions. Again, however, we have not seen that happening yet on a large scale across the country. The next and most popular way to keep people out of the system is through formal and informal diversion programs. Now, these could be as informal as a local county prosecutor saying, if you go to drug treatment, I won't charge you with this crime. Now, those aren't recorded anywhere, but certainly those sorts of diversion efforts happen, and they happen with some frequency. More formal diversion efforts include things like deferred adjudication, where someone will be charged but not convicted so long as he or she participates in a program specially designed to reduce risk. Often this involves the use of specialized courts. Most popular are drug courts, though mental health courts and other specialized courts that focus on particular criminogenic problems are also growing in popularity. And the point of these programs is ordinarily to either avoid conviction or at least avoid a custodial sentence for persons who don't pose a large risk to the general public. And finally, although it has a little bit of a back-end effect, I put this in the front-end effort column, expungement options that allow people who have been convicted to then later erase their criminal records, so to speak, although they are used with varying success in varying jurisdictions, are often designed to help reduce future risks to people that attend having a criminal conviction. As you've already heard, of course, once you have a conviction, things become more difficult. It's more difficult to secure housing, to secure financial aid in some instances. There are many collateral consequences that attach to conviction. So by removing some of those barriers for persons who have committed offenses, particularly first offenses, often we could try to prevent those people from re-entering the criminal justice system. The second category of reform efforts I'm going to call back-end reforms, for a nice parallel. Those have divided themselves into several categories as well. First are ones that focus on reducing revocation. You heard some mention of California's efforts in this regard. There are a growing number of jurisdictions that on any given day, if you sort of hit the pause button and did a freeze frame on the prison population, you would find that more people are entering prison on that day as a result of revocation from community supervision than are entering it as a result of an actual new offense. And those numbers are staggering because what it shows is that revocation rates, failure on community supervision, is driving growth in prison populations in many jurisdictions, including Wisconsin, which is where I'm from. To reduce revocation, there are several different legislative reforms that have been tried. Some of these increase the use of formal diversion options for persons who have committed a violation that would otherwise return them to prison. You heard that California, for example, either does not permit return to prison in some cases or has limited the amount of time for which someone can return to prison on revocation. That's certainly one way of dealing with the problem. The other is creating alternative intermediate sanctions, for example, authorizing correctional officials to hold people in jail for limited periods of time, short of sending them back to prison for a more extended period for violations. Capping the length of revocation is another way, California's tried this, to limit the amount of time someone can return to prison and therefore the number of people who are serving revocation sentences in prison at any given time. You also will see And this is a category I'll talk more about in a moment because I think it's the most popular and most rapidly growing category of new legislation designed to combat growing custodial populations, new legislation that provides for early release from custody, that lets people who are serving determinate sentences or indeterminate sentences have a means of getting out of prison early. And finally, and this goes back to concerns over both revocation and limiting the number of people coming out who remain under correctional control, many states have reduced periods of supervised release. So the amount of time someone who's leaving prison is still under government watch, so to speak, and provides for early termination of supervision in cases where people are complying with all the rules to which they are subject and are generally deemed to have been a success rehabilitation-wise. So I do want to focus, come back to my history lesson, and talk about legislative relief mechanisms. Sorry, I have a little glitch in my slide. Ignore judicial modification for just one moment. These new mechanisms are proliferating across the country, and it's happening at a very rapid rate. Not surprisingly, as custodial populations grow, you heard about all the pressures that exist on prisoners, on correctional officials, on state agencies. They need relief, and they want relief quickly. And as a result, they're passing all sorts of new legislation and categories of legislation designed to get people out. And these generally break down into 4 basic categories. They include increases to parole eligibility, credit for time served against a sentence, and these can occur as a result of educational program participation, vocational program participation, drug and alcohol treatment. Compassionate release, which has been a very popular, though underutilized mechanism that allows for early release for people who are elderly or suffering from serious illness and who therefore also cost the state a lot more than other prisoners in terms of caring for their health. And finally, judicial modification, which returns the sentence to the defendant to the sentencing judge for a determination whether changes in circumstance or demonstrated rehabilitative behavior may justify a reduction in sentence. So those are the 4 big categories. What I want to suggest is as states consider each of these categories, it is critical for them to engage in an analysis of why parole and early release mechanisms failed several decades ago. Before we begin to do what we used to do routinely, which is release people early before the termination of their sentence, it is important to account for the public concerns that led to the dissolution of early release. And unfortunately, most states are not doing that. I was delighted when I read the West Virginia report to see that a significant portion of it is taken up with a conversation of the importance of educating citizens and engaging the public in a discussion about their public safety concerns, about their values, about the ways in which they want to see sentences executed. Because if there is not a perceived sense of legitimacy of process by the citizens of your state, your legislation, even if it's wonderfully conceived in every other way, I predict would be doomed to failure. And in fact, I have 2 examples very close to me, my own home state of Wisconsin and our neighbor Illinois, that have seen this exact thing happen. Illinois passed legislation designed to allow some categories of low-level offenders out of prison early. At the same time, they were also informally allowing prison administrators to give what is called meritorious good time credit, discretionary awards of sentence credit, to prisoners, many of whom were only within a month of release. What happened was rapid, large-scale releases of large numbers of prisoners. We know that a certain percentage of all people released will mess up and come back. That's inevitable. We know that statistically. Of course, the larger number of people you release at one time, the more likely you are to see large numbers of recidivism rates. And that's what happened in Illinois. There had been no attempt to have a conversation publicly about the decision, especially to allow prison administrators to award credit, and as a result, the new legislation was repealed within months of passage. And there have been no further efforts to institute early release in Illinois. My own state of Wisconsin, after conducting a thorough assessment with the help of the Council of State Governments, tried to implement new legislation about 18 months ago. We passed Act 28, which provided several mechanisms for sentence reductions for persons who participated in rehabilitative programming. There was not, again, engagement in the way that those decisions were going to be made or executed. Not only were few release decisions made because prison officials were uncertain of public tolerance for them, but I am told that last night our governor announced that that act will be repealed as well as part of our new budget bill. So again, cautionary tales that I hope don't suggest to you that you should not be engaging in this conversation, because you should. It's critical, and the results, as you've seen from listening to the story of California, can be devastating if you don't. But I would encourage you to learn lessons from other states and really engage in some deliberative and creative conversations. The report that you have before you provides a wonderful roadmap of talking points with a lot of creativity and thought, and it appears preliminary buy-in, at least from many branches of your government. So I thank you for bringing me here, and I hope this is the beginning of a larger conversation for your state. Thank you.
I'm going to try and ask the panelists a couple of short questions and then bring the audience into this. We seem to have some common ground that there is a serious problem, and what I guess I'd like to ask the panelists, or first I'll start with you, Norb. What do you see as the biggest impediment to getting reform actually to work? Is it money, or is it something else? You said, you and Professor Bastress said you made a lot of recommendations, but so far most of them have not been acted upon.
There are two things. One, of course, is money. It always costs money to implement new programming, and it's ironic that the criminal justice system in West Virginia has always run about number 49 or number 50 as far as investment of state monies into the criminal justice system. We just have not invested in it. But secondly, and I think probably more importantly, is the attitude and is the really the public information discussion that we've been talking about. I know that during this current session of the legislature, I believe it was Senate Bill 196, in effect created a new law, the law for attempted robbery when you don't have a gun, you just have a bar of soap or a rubber ducky in your pocket or something like that, and you put someone in fear and trembling. It was actually part of attempted robbery. They could prosecute it. They could offer a sentence of 3 years to 18 years indeterminate. They created this new offense now and put in that it shall be a determinate sentence of anywhere from 10 years to 50 years. That's going to add extra prison beds. With that sort of attitude that we still have to get tough on crime, it is very tough sailing to try to convince politicians who must get reelected that community service and community corrections and dealing with criminogenic needs will in fact reduce the recidivism rate and produce public safety.
Ben, what about you?
I think I don't disagree with much that was said. I think money is a big issue in California. If you look at the budget, the general fund, 40% go to education, 10% to the prisons. There's half the budget, and the fact is, if you look at, you want to add more money and do programming and do things, then are you taking dollars out of education, and isn't that going to lead to then the prisons? It gets this catch-22 of how do you stop the cycle, and it's been difficult in California. The political will to take on programs to incarcerate less is very difficult, and the lack of money. If you look at California, it's not a state that really does over-incarcerate. It really 12% of the population, 10% of the inmates. So it's not like it's double the average. You do need some cells, and you have to spend money for that, but you need to have the political will to do reforms for those that could be treated differently.
Do you think that there's still a lot of fear, in terms of people that are in the legislature to enact some of these reforms because they think there's a Willie Horton around the next corner and they're going to get blamed for it if they adopt some sort of significant early release program?
You're trying to get me in trouble on the webcast if anybody in California is watching here. I think there is a fear. I mean, you know, that there is, two of the panelists talked about it, there's an education that's necessary for people to look at and for people to understand, because people have to, you know, go and account to their constituents. And if you look in California, there's a recent law that was passed called Marcy's Law that has a truth in sentencing provision and basically says you can't release prisoners early. It takes that thing off you know, fix off the board for California because of that provision. The only thing that you can do is have the statutory authorized credits, which is what was done a few years ago and what they're looking at now, you know, different ways that wouldn't, you know, be in violation of that law. And so you have, you know, people elected are reporting to the people that are, there's some fear there, and you're going to have the, you know, there are political realities of looking soft on crime. I certainly think that's an issue.
Cecelia, you said that in your state that some good ideas look like they're going by the board. I mean, is there any way to turn that around?
I hope so. But I think that it does involve multi-branch conversation and involvement, because I think each jurisdiction is going to be unique in what it is willing to accept in terms of trade-offs in incarceration rates for what is a good fiscal deal. And I think what we find is that the more you can get the public involved in a conversation or invited to look beyond the rhetoric on any side, whether it's that we're saying we're tough on crime or we're smart on crime or we're using evidence-based practices, those are all potentially good things. Everyone thinks that we don't like crime. Most of us want to be safe. So it's important to go deeper, though, and say, okay, well, if these are the choices available to us, we can stop funding higher education and have more prisons, or we could do imprisonment differently and have better education. Then people get into the mode they are in their daily lives. All of us have to make tough financial decisions. And when we ask the citizens to really engage in that deeper conversation, I think we can find that they're more willing to do it than we may believe.
And when you say getting citizens, you know, not formal policymakers, legislators, deeper involved in the conversation, I mean, do you mean holding community forums, or are you talking about the state doing its, you know, utilizing, say, the resources of a public television network to try and disseminate the message? I mean, how do you really get the public involved in thinking about this more?
I think that there are lots of different ways and that they should all be tried and experimented with. Certainly, legislators, policymakers, academics, people who work daily in the criminal justice system all need to be at the table involved in having a conversation. But I do think that when you talk about nonprofit service providers, when you talk about educators within communities, they have a place and a voice and important things to say as well. And so certainly the media plays an important role, always plays an important role in criminal justice, and I think could play a role beyond simply publicizing the Willie Horton case.
Craig, you've studied human behavior for many years, and some of what this discussion seems to be has to do is fear, having to do with the fear of change being an impediment to reform. Could you talk a bit about that and what is to be done about that?
Well, I think fear is a huge impediment here. But let's reflect for a minute on what the last 30 years have brought us in terms of dialogue and conversation about these issues. That graph I showed you where the incarceration rate starts to go on a curve that's almost straight up, that didn't happen by accident, and it wasn't really driven by crime rates. If you look at the crime statistics, that accounts for a tiny percentage of that massive increase in the rate of incarceration. It was driven largely by politics. It was driven largely by, if you'll pardon me for saying it, a dishonest conversation, which we've been having for 30 years now. A dishonest conversation which suggests that we respond correctly to crime by incarcerating more people for longer periods of time. And politicians have lived on that. They've lived on it. It's almost like a drug that you have to use. You know you shouldn't use it, but every time you say it, it feels good, and people vote for you. And so you keep going back to it, and you keep talking about it. And then you're afraid to withdraw from it, because what will happen to your electability if you start talking about another way to go about this. You've helped to get the public so not only afraid, but so afraid that there's only one solution that can alleviate their fear. Now, reflect on the pictures that I showed you and the numbers people have been talking about. Ask yourself how one more day living under those conditions will make the public any safer when somebody comes out of that environment. And that's the conversation we're not having. And that seems counterintuitive because, of course, it's going to be a public safety problem if people come out of prison. But the only way we can alleviate those criminogenic prison conditions is by getting people out of prison sooner rather than later and not exposing them to the things that make it more likely that they'll commit crime when they get out. Very few politicians are talking about that, not because they don't know it, but because they view it as political suicide to be talking that way. I mean, yes, there are this kind of conversation we've had today, this I think incredibly sophisticated West Virginia Overcrowding Committee report. Few other states are talking about it. You've heard about some of the reforms that are being tried, but public education is critical in this process. It's going to take a while to reverse 30 years worth of talking about incarceration as the only solution to this problem.
I'd like to open it up to the audience who's been listening very patiently. If there's anybody that has a question, why don't you step to the microphone and we'll field some. And you can direct the question to anyone you so choose.
Thank you for coming, first of all, and I'm not sure who to direct my question to. And this could probably be an entire another talk, but what are any of y'all's impressions of a solution involving not state funds or reduction of prison populations, but instead an encouragement of private operation of prison industries that would combine cheap labor and the rehabilitative aspects of prison labor as a profitable model to expand facilities without necessarily giving up state standards of criminality? Or would this increase of prison industries prohibitively incentivize a commercial hold on criminal law or a reduction of standard of living to an unconstitutional level? Or would this have no meaningful or feasible solution and that the only true solution is through criminal policy reform and education investment?
You want to take a crack at that?
Thank you. There are prison industries already in both federal and state prisons. They are limited to non-commercial ventures. And there's a reason for that. We don't want the prisons with their ability to pay less than prevailing wage to compete against other businesses, other people who have to make a living in the community. And so, to build a premise that, we can build a prison system based on the prison labor, I think is a false premise. It is good to keep the inmates working. As Professor Haney indicated, when you've got people serving their entire sentence never having done anything, that's bad, because that's when you pick up your bad habits. But I don't see it as a feasible solution to the issue.
Would you not be able to regulate it in the same way that states also regulate their own industries, or is that not a possibility due to the standards of what prisons have to be?
I think it really goes to the entire picture of what you have in society. Do you want this prison labor, again, which can be paid minimal and can be very inexpensive, but for the fact that you're housing and feeding and three huts and a cot, you are competing with the private sector, and I don't think we want to take away that ability of entrepreneurs to make a living, a fair living, without having to compete with the state venture.
Thank you very much.
I actually want to ask you all to give us some advice on this. I was a trial judge for 20 years, state Supreme Court justice for 12, and I chalked the whole issue up as being political cowardice. I reduced a prison at Huttonsville from 829 prisoners to 550, and I had the pleasure to read 9 editorials one morning, the same editorial in 9 different papers around the state, entitled Let 'Em Loose Larry. Subsequently to that, I was elected to the state Supreme Court. And I think it can be done if you educate people in the right way. And we know the answers. We know the answers. We just don't have the political courage, judges and legislators, to do the right thing. What's your all solution?
I think courage is a great word because it really does take leadership. And, you know, one point I didn't make, and it's worth making, is that actually some of the most promising advances have come out of traditionally tough on crime states. Texas and Mississippi have made amazing advances in handling their custodial populations. And I think in part it's because there's some base level of public confidence that there's leadership there that cares about public safety. And then when legislators say, you know what, we can be safe and we can send dangerous people to prison and keep us all safe, but not everyone in prison at least goes in dangerous, and those people we need to treat differently, then they have a credibility. But you're right, courage is what it takes.
Norb, you want anything to that?
I think a constant conversation between the executive branch and the legislature, and perhaps behind closed doors as well as in public, could be helpful. You know, yes, the legislators are brought up to date with public hearings and so forth on the picture, how many people we have in prison and that sort of thing. But to truly have an educational process where they realize that criminogenic factors can be taken care of, and that it's not softened crime to take care of them, but that it makes sense to take care of them, and that it doesn't make a difference if a person serves 24 months or 23 months or 22 months. You can let that person out in that 22 months. It's really not going to be a difference on whether or not they recidivate, provided that you have dealt with the criminogenic needs. So I think that the professional conversation that should take place between those of us who are perhaps classified employees or educators and with the legislature in particular, and then looking to work with the entire executive branch is the only way that we will avoid coming back to court and asking the justices to tell us what to do.
I want to just throw in one. I like to appreciate the responses and particularly appreciate the judge raising the point. I do think that, and this is again a longer term solution, but those of us I think that are in the legal education business also need to start doing some more just questioning of some of the premises of our criminal justice system. It's and this is again the subject of a longer conversation, but it is really shocking to think that somebody can be sentenced to prison for 50 years, even though it's his third crime, but not a violent crime, for stealing $160 worth of videos, and that somebody that steals literally a fortune and wrecks a community with mortgage fraud doesn't go to jail at all. And it does say something. It does say something very fundamental about some of the underlying premises of the system. I mean, and there are other examples I could give of that as well. I mean, it's very rare for, I know here in this state and a lot of other states, I mean, workers die in factories or in mines due to unsafe conditions, and it is an extremely rare event for somebody that's involved in something like that to go to jail either, or even or rarely to pay a significant fine. Enough of my soapbox for the moment. Next.
Thank you all for coming. I think something that we've not touched on in today's conversation is the role of prisons as an engine of economic development, especially in rural states like West Virginia. I know that Preston County is certainly happy to have its federal penitentiary at Hazleton, which is a terrifying place. I have been there. I wondered if you could all comment on the role of prisons as economic development, especially for depressed states, and how that will play in the conversation of prison overcrowding. Thank you.
Ben, I'd like to start with you because I gather you've had some experience with this.
So, in California we have the Prison Industry Authority that, does things. I think it's a program certainly that could be expanded and looked at in other states. We do have some vendors that will come in and work for California. There are laws, though, that minimize it. There are some parts if you give, the the work to prisoners, that you could effectively harm another company or an industry, and but I think it can be used. And
if I could just respond, I think I'm sorry, I was not clear. What I was looking at was the actual employment created by the prison for prison guards as public jobs with benefits. If you're in a depressed area where the industry has left, everyone is grateful for these jobs, but they carry consequences.
yeah, so in California we have, you know, a high unemployment rate. There are certainly areas that are really depressed and are looking to. They're more willing to take on prisons and having built it certainly would help those economies. You know, the fact is, though, you're taking, if you're going to just keep expanding prisons, and you're taking it from one area and putting it in the other. But certainly the areas you put it there has helped markets that were depressed and could help markets in California that are depressed.
I would add that, yes, it is a potential job creator, but putting them in isolated areas is really going against the grain of good rehabilitation. You are taking persons away far distance from their family, from any support that they may have. Now, some may have no support. They may have destroyed all bridges and so forth. But you really don't want to put people in such isolation that they can't be rehabilitated, that their family and friends can't visit them. And so I think that's something that has to be balanced.
I just to add quickly, some communities have found that the promised economic boom either never materialized, or the unexpected and unintended consequences proved to be more significant or serious than the apparent economic trade-off. So it's not all, I mean, it's not always a positive outcome. We've had this experience in California where communities actually are sorry that they cited a prison in the community, even though economics appeared to be an incentive for doing so. The other thing, though, a more problematic feature, just to expand the scope of your question, most of you I know have heard the term prison industrial complex. When you create a system as vast as this one has become, and you have 2.4 or 6 million people in prison and people in jail and people on probation, you've created associated industries with economic interests in keeping this system large and expanding. I mean, these are even though there are not a lot of for-profit prisons in the United States, some but not many, there are for-profit companies that service these prisons in all of the ways that keep them going. And those industries have become major players in state houses all across the country, lobbyists to lobby for the interest of that industry are part of what's keeping the pressure on this system and part of what is fighting against attempts to constrict it because there are economic interests involved.
Yeah, I would very quickly echo the unintended consequence. And you mentioned Hazleton, and it does come to mind is that this is a high-security prison with some very, very dangerous people who rural Preston Countyans are not familiar with. And, of course, Bob Byrd worked very hard to get that center there and worked very hard to ensure that the percentage of jobs will be West Virginians, and it's creating an oil and water mix, which has not been pleasant for a lot of Preston County families.
I just want to say at the moment that we very much appreciate how interested the audience is. I would just like to say that we will have to cut this off with the people who are currently in line. But all of you that are in line, I'm going to exercise a brief bit of dictatorship for the moment, but we can continue the conversation on stage. Please go ahead.
Okay, my question is in regard to gender. As we see an increase in the female population in prisons, are the prisons themselves doing anything novel to address either overpopulation or rehabilitation of the female population that might be able to be transferred to the male population?
Women are definitely one of the fastest growing groups within the prison population. The number of female offenders going to prison is increasing at a fairly dramatic rate. And so states that previously have sort of ignored issues that might be special to women within the prison setting are now being forced to confront them. I know there have been a number of class action lawsuits around the country challenging particularly the failure to provide adequate medical and mental health treatment to women in facilities. although it is true across the board for men and women in prison that a disproportionate number have suffered from physical or sexual abuse at some point in their life, that number is even higher for women. And so the treatment needs are different and increased, as well as some of the physical health needs. My general sense is that although this is an area of growing awareness, states are very kind of behind the game in recognizing that this new group that's growing so quickly needs special treatment and special resources.
Craig, do you have anything to add on that one?
Well, no, I mean, I just echo what was just said. Also, always keep in mind the racial disproportions. So the rapidly increasing number of women in prison systems around the country, and even more rapidly increasing numbers of women of color. I mean, this is a crisis that affects different groups of people in this society disproportionately.
Sir?
So I was very obviously out of the room for about 45 minutes of your talk. So as soon as I ask a question and you say, we answered that already, I'll sit down. I don't expect you to repeat yourself, but on the possible instance that you don't. I've been interested in this issue since for more than 40 years, and for 10 years before I graduated from this school, when I was at the Petersburg Federal Reformatory for 2 years for draft resistance, Vietnam era, and I saw the first changes in the federal prison system when the LSD was made illegal. I remember the first guys to be arrested for a couple nice young middle-class boys from Alexandria who were casualties, early casualties of the drug war. Seems to me that's been our failed attempt at dealing with a medical problem, these terribly addictive substances, with incarceration. But there's another aspect of it, and I think in the law school it's important to look at that. Is what purpose does this really serve? You know, some people say that summary judgment became popular amongst courts when they started letting women and African Americans on juries, and you couldn't trust, and women especially, you couldn't trust, white men couldn't trust to have the decisions made by other white men. And so they started changing the system, left it up to judges. But when the Civil Rights Act came along, all of a sudden a lot of poor people and black people, especially poor black people, the deadly combination, got the right to vote. And if you look at what interest is really served by incarcerating a lot of people, I don't think it's crime. There hasn't been that much of an increase in crime, but it really has been very effective in changing the difference. One more point. William Rehnquist started his career as a jurist, before he was a jurist, as a young lawyer, challenging black voters in Arizona. I mean, that's well documented on the lines, trying to discourage that vote because, you know, elections turn on very slim things, and Karl Rove understands that, and any politician knows it. So I just want to echo what somebody said early on. I think it was, I forget, you said about that new Jim Crow. If you look at the disenfranchising effect of large-scale incarceration, you'll find that it really serves certain political interests in this country. So I think that is at least as important a part of the politics of prison overcrowding as the politics of fear on crime, which I understand, you know, California gets stirred up and, you know, you have people, it's easy. But when it combines with changing the results of elections, then I think you have a very vital political motive. Just a couple observations.
I'd just like to make one quick comment about that, is simply to say that in a number of places now, there are moves afoot to change or modify felon disenfranchisement laws. It's become a very significant issue in a lot of places, and I suspect it'll be playing out over the next several years. Sir?
Good afternoon. I'd like to thank the panel for all your thoughts, except perhaps pointing out the similarities to me between a military barracks and a penitentiary. But in any event, what I'd like your thoughts on is for the category of incarcerated prisoners who are repeat offenders. And we have a saying in this society that you do the crime, you do the time. And what I would suggest is that's what we say, but that's not what we do. And for a lot of crimes, even nonviolent crimes, what we really do in this society is if you commit a crime, we make you pay for it for the rest of your life. And to what extent does that, you know, lead into the repeat offenders, and how can we decrease the prison population by fixing that? And someone's going to say that I'm being soft on crime. Well, if you're not comfortable with giving someone a clean slate after they've paid their debt to society, my response to you would be, then you either haven't punished them enough or you haven't done a good enough job rehabilitating them. But if you believe in do the crime, do the time, then you shouldn't have that issue. So thank you.
Anyone want to comment on that?
I would say that I understand that Professor Alf Blumstein up at Carnegie Mellon has started some research on what he calls redemption. How long does it take for an offender who has done his time to, in effect, be redeemed by society, for society to forgive him and allow him to accrue jobs and opportunities as any other citizen has. Yes, restoration of electoral rights is an important step in that fact. I have no idea where the research is going, but it will be very interesting to find out what length of time people expect before someone who may have committed a crime when they're early 20s, is going to be accepted in the community again.
Much of this has to do with legislation, too. I mean, the proliferation of legislated collateral consequences for crime has been staggering. And across the country and in the federal jurisdiction as well, what we see are that more and more areas are affected by prior conviction. So your ability to obtain licensing for employment, for jobs ranging from being a teacher to being a barber, have just increased, as well as housing options, financial aid options, and many other areas where if we want people to succeed, we need to be removing barriers rather than putting them up. And so I think more increased legislative attention to sort of documenting what are the ways in which in our jurisdiction we're limiting people's ability to succeed are worthwhile efforts.
A great book by a psychologist named Shad Maruna called Making Good, in which he's done some extensive research on the positive effect of providing people coming out of prison with a redemption narrative for their life. You give them an opportunity to achieve and attain things while they're in prison, which we frankly do very little of in the United States. But then you give them a different way of thinking about themselves, rather than a permanent lifetime stigma, as you were alluding to, not just the actual real barriers, but the psychological barriers that people leave prison with. Never you get past the fact that you've been in prison, you're an ex-convict, you're stigmatized for life. Give them a way of thinking about themselves that's different, and that's the best possible way of keeping them out of prison. So he's got a lot of studies, a lot of analysis of this issue. It's a good read and right on your point.
Those are very good responses, and I want to just add one other thing myself about the notion of the permanent stigma. Stick around for just a second, sir, because I want to just give you a contrast point. This is, I think, again, I want to go back to the values question of blue-collar crime versus white-collar crime. There are numerous instances in this country of large corporations perpetrating defense fraud. There have been judgments against them, and it is extremely rare in this country to debar a company from getting another federal contract after they have looted millions of dollars. And again, it just sort of goes back to what some of the basic values are and who's got a better lobbyist. President Hardesty, next question.
Thank you for coming. And law review members, let me just say I'm very proud of all of you. This has been an outstanding day for all of us. Dr. Haney, I was struck by the correlation between the decline in mental health facilities and the crowding in the prisons. And my question for you is there any attempt in the prison systems across the country to do specialized prison? I'm sure there are for gender. I'm just wondering if there are institutions that I don't know the answer. Are there institutions that specialize? And Ben, if I did my math correctly, if we took all the drug convictions out of the California prison, you'd meet the Supreme Court requirement. And I'm just wondering about, is there any feedback to the political system as to the types of people that should be incarcerated, should not be incarcerated? I know federal judges have serious doubts about national federal drug laws and mandatory sentences. So those were two possible remedies that I just wondered if there's been any progress on those. And I'm not going to go to the decriminalization of drug questions because we are on a webcast and you just couldn't possibly.
Yeah, you don't want me to. You don't want me to, and I'm not going there. I will say, and I think the judge made the point earlier about, I think you can do it, and, it takes courage, and, the fact is, a lot of times people get too stuck in their point of views on the, what you'd call really tough on crime and soft on crime, and the fact is the answer's probably in the middle. There's people that need to be incarcerated that are a danger to society, and you need to have appropriate cells with appropriate programs for them that when they come out. And the fact is that you need to look and have a risk assessment and look at people and who needs to be incarcerated and who can be treated a different way. There's people, even, you can't treat somebody about the people with drug problems. They all can't be treated the same way, too. There are people that have drug problems that can be treated with flash incarceration and other methods that work, where others that doesn't work when they have a drug problem. They truly need treatment. And so, even within one category, there's categories within that. And that takes time and takes resources to treat those people appropriately.
And on the issue of mental health care, almost every state has a facility or several that are specialized mental health, criminal justice type facilities where mentally ill prisoners can be sent. I think it is fair to say, and there are a few exceptions to this, but this is overwhelmingly true, that the number of such beds that are available pale in comparison to the number of people who need to be placed in them. Pale in comparison. I mean, we're trying in California and failing providing this care in the prisons. The waiting lists to get into our specialized facilities are months and months long for people who are desperately mentally ill, the most serious mentally ill. And sadly, oftentimes where these prisoners end up is not in a mental health type facility, but rather in an isolation unit. Because these are the people who are getting written up repeatedly for disciplinary infractions, and they work their way into a security housing unit or a so-called supermax prison. I do a lot of research and do a lot of work interviewing people in these places, a higher percentage of mentally ill people in those units than anywhere else in the prison system. And it's because of the lack of resources and the fact that without mental health resources, they simply can't get traction in the system. And they cause problems. I mean, the correctional officers who write them up, I understand why and how that happens, but the source of the problem is not willful misbehavior. It is rather a mentally ill prisoner living in the kinds of conditions that we've been looking at.
Thanks again to the panel. I'm a professor here, and I've taught for the past 7 years in our clinics, and a lot of the clinical work is focused on children and families. And one of the things, when I moved here and I started doing this work, it became quickly apparent the impact of substance abuse and incarceration on families and children. And so my question is focused on substance abuse in West Virginia in particular, and the role of how do we deal with that? Because we see, I've seen so many people who have substance abuse problems, who steal a small amount of money, who wind up in prison, who get released on parole, who violate because they test positive for drugs, and then the impact that has on their kids because their kids are deprived of their care and the economic resources that parental employment would provide. So it seems like it's a difficult problem. So my question is, to what extent do the prisons and jails in West Virginia provide substance abuse treatment? What type of treatment is it? How do you guarantee or assure that it's effective? And what happens to people when they return to the community? If you could discuss the lack of substance abuse programs for low-income people in the state, and to what extent the panel that looked at prison overcrowding is also looking at issues of preventative substance abuse programs, treating people before they get into trouble and get into prison.
I think that one's in your ball court.
The prison system has a number of therapeutic communities as their base treatment model for drugs. They also have an alcohol treatment education program for those who are in and whose drug of choice has been alcohol. The therapeutic community model is good. I mean, it's at least a minimum 6-month model. They are isolated from the rest of the population within their prison. They work together and support each other and so forth. But as I indicated earlier, the problem really is not that the treatment is ineffective. It's that it is not continued. You cannot expect someone to go back to the community without any support system after you've been in a therapeutic community, which is nothing but structure and support from fellow offenders, fellow addicts. And to me, the real shortcoming that the state has is in providing community-based mental health and community-based substance abuse services. Our community corrections programs have managed to contract for some of those services in areas where they're operating, and that's sort of on like the front end, as Dr. Klingele was talking about. Most of those patients, or most of those offenders in those programs, are early in the system yet. They have not penetrated deep into the system by committing serious felony offenses. Many of them are DUI. But beyond the community corrections programs, it is my perception that we have very few, very inadequate resources for outpatient therapy, outpatient substance abuse monitoring, outpatient substance abuse treatment of any sort.
Can you give recommendations for what we can do as a law school to assist with expansion of those resources?
I think if someone from Law Review is interested in doing some statistics and analysis on the population of the West Virginia prison system, it'd be interesting to find out what the involvement of the offender was with drugs at the time of the offense, even if it's not a drug offense, especially if it's not a drug offense. And then to correlate that with where is the money going for community mental health in this state. We have contractors, DHHR contracts out with providers throughout the state. Every state is supposed to have a certain number of providers and so forth. I think a discussion needs to be had with DHHR and with the contractors on where are the dollars going. Are they going to people that are truly at risk of creating public safety issues, or are they going to the neurotic well that are easier to treat and are perhaps nicer and cleaner and more middle class than some of the people who really need it, the poor people that have been exposed to problems?
Thank you.
Henry, I would like to add an unrelated announcement. My con law class will reconvene at 1 o'clock on Friday, and we will have the regular 1 hour and 15-minute class.
Thank you all for being such a spectacular audience.
There are WV cookies outside. Go eat some.
Get up here.